And I'm Brianna Lathan.
And we're from the University of Louisville Brandeis School of Law Human Rights Advocacy Program. The program evaluates the needs facing Kentucky's immigrant, non-citizen, and refugee community.
These citizens face unique challenges when trying to do simple tasks that we take for granted, such as finding healthcare providers, resolving landlord-tenant issues, and enrolling their children into public schools. Language barriers are some of the largest obstacles that make navigating a new environment discouraging. This video will discuss a federal policy that seeks to shrink that obstacle for the limited English proficiency, or LEP, population.
True or false? Institutions that receive federal funds must have a language access plan to ensure that the LEP population has meaningful access to resources. True. Title VI of the Civil Rights Act of 1964 and Executive Order 13166, signed by President Clinton, require that public funds to which all taxpayers of all races, colors, and national origins contribute not be spent in any fashion which encourages, entrenches, subsidizes, or results in racial or color or national origin discrimination.
Language access is the ability to communicate effectively and receive assistance when you ask for it, the ability to have access to federally funded programs and activities conducted by service providers, and the ability to survive. Because this right is so important, federal law requires all institutions that receive federal funds to have a language access plan. A language access plan is a document that contains an institution's plan for translating all of its vital documents into the native language of persons with limited English proficiency. Language access applies to any institution that receives federal funds. Federal funds are considered to be grants, financial contributions, any type of training, equipment, property, or other things necessary to operate a business. For example, institutions such as law enforcement, healthcare, housing, social work, and education, and any other institution that receives federal funds.
When any of these institutions or agencies receive federal funding, there is an agreement that the agency will universally comply with Title VI. This could be providing translated versions of all their vital documents, making translated documents available through their online website, and providing multilingual staff or telephone interpretation services. All of these services combine to provide parties with the LEP community with meaningful access, which is a requirement for compliance with the law. Now, although this sounds like an easy standard to satisfy, noncompliance with LA is rampant.
Although the federal government has created a uniform language access standard for states to follow, it has not made enforcing the standard a priority. Consequently, institutions and agencies either have outdated plans or they do not have plans at all. This is reflected in survey results from the 2015 survey by the Human Rights Advocacy Program. The survey polled 50 law enforcement, healthcare, housing, social work, and education agencies in Louisville. The survey revealed that language access in Louisville suffers from a lack of interpretation services for providers' clients when seeking services from government agencies or organizations, for example, agencies such as the Domestic Violence Intake Center or courthouses. The survey also showed that agencies were unaware of their requirements or refused to give information about their plans. Finally, the survey revealed that language access in Louisville is severely impacted by budget cuts.
Complying with the language access standard is simple. Institutions that receive federal funds must submit a language access plan to the Department of Justice for review. This plan needs to demonstrate awareness of the LEP population served, describe language access policies and procedures, and have knowledge of the needs of the general LEP population. To make compliance even more simple, here is a 4-factor test. 1. The number of the LEP persons in the eligible service population. 2. The frequency for which the LEPs come into contact with the program. 3. The importance of the service provided by the program. And 4. The resources available to the recipient.
Although agencies are not intentionally out of compliance with the language access requirement of Title VI, the general lack of compliance reflects a need for education on the law and a need for education on the consequences that come with restricting the LEP population from accessing law enforcement, healthcare, housing, social work, and education in a meaningful way.
Restricted access to these institutions could result in a large population of resident Kentuckians being unable to participate in the basic day-to-day affairs. Finally, these members pay taxes, and their tax dollars contribute to the federal funds that help these institutions operate. Thus, there is not only a legal duty to comply, but also a moral one.
To recap, federal law makes it clear that no person in the United States on the ground of race, color, or national origin be excluded from participation in, be denied benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. Any institution that receives federal funds is required to comply with the language access requirement of Title VI.
Each agency should submit their plan to the Department of Justice and actually provide meaningful access to the limited English proficiency population.
The Human Rights Advocacy Program would like to thank the Louisville Bar Association for their funding to make this video possible.
And thank you to our videographer, Rachel Burnside, to our Education Access Fellows and volunteers for all your hard work.